So last lecture, let's have a quick look on all the slides. Okay. So we discussed about this, okay, the meaning of the word vitiate, and then definition of coercion, okay, general technical definition. And just now, when I read through, actually we are referring to statutory definition. So we have section 10, section 1, section 14, all right. Section 14, clause A is about free consent, that's the keyword. And then section 15 just now, okay, Contracts Act 1950. And this is the limb that I was talking about just now, okay? Even though from the provision, you cannot see the word limbs here. So this is for the purpose of interpretation. And how do we know? From the case law as well. This is the way the provision, the statute is interpreted, okay? Cases will help with the interpretation. So two limbs here, it refers to two ways of in what way coercion can be committed, can be done, basically. And then another thing that that we need to know, okay, this is the analysis of the provision. So if we read deeper, okay, if we look closer, so basically because very, very specific way of committing a coercion here. So now it limits, this is the effect, okay, the legal consequence. It limits the wrong, okay, it limits the act, the wrong, or threaten wrong, threaten act, okay, to only certain act, okay, to crimes under penal code alone. And it does not include tortious wrong. Actually, the correct spell, I haven't made correction. Tortious here, T-O-R-T-I, okay, it's not T-O-R-T-U. That one a different meaning, okay. So tortious wrong, we want to relate with torts act. Okay, you're also learning torts, kan? So whatever torts, so not really something which is committed tortiously, not necessarily crime per se, not necessarily crime under penal code. So if it is tortious act, then it is not caught by section 15. It's very hard to prove coercion. Okay, or in other way, torts is about civil wrong. Okay, so if it relates to torts or civil wrong, then it will not amount to coercion within the ambit, within the scope of section 15. So section 15 is very limited in that sense. Okay, you have to really cross-refer, double check, is it under penal code or not? Okay, so now what's the effect of this limited scope? Okay, what's the further effect here? Okay, further legal consequence. So now it makes, okay, the scope of coercion obsolete or outdated. Meaning here, not everything we can prove it under section 15. Having said so, that's why we don't have many cases which was brought under section 15. Most of the time, parties, they prefer to bring the case, okay, file the case under section 16. Okay, 16 we are going to discuss as our second topic later. Okay, but again, 16 has its own elements. Okay, 15 different way of proving. Okay, so now the effect of the limited scope just now, which we need to double check or cross refer. Okay, make it within the scope of penal code. So it makes the scope, it makes the provision here obsolete, outdated, or not of much use lah. Basically, that's why we don't have many cases which was brought under section 15. What more, we want to know, is it, I mean, if you bring it under section 15, can you be successful or not? So we have at least two cases for us to discuss. Okay, we have tag 1 and later we have Nuri Asya. Two cases, okay, in which the court discuss specifically. Okay, mean that here, okay, this is about section 15. Okay, so we have the first case law that we want to discuss for today. Tag 1 trading, the full citation is in your course outline. Okay, you are getting your course outline today. Actually, I got it from department already, but I haven't given it to you. Okay, I'm giving it inshallah today. Okay, tag 1 trading and hydrotech engineering Singapore. Okay, as Senuran Berhad. And then what's the importance of the case here? Okay, before we go to the facts, this is the principle. Okay, this is the ratio that we derive, okay, that we extract from the case. So most of the time when we talk about case law, other than discussing the facts, the judgment decision, the issues, what's the important principle, okay, that we learn, okay, that we can apply to the problem given. So here the principle is that first, okay, the court said clearly, even though in the provision it doesn't say. So the case law says it clearly. There are two ways of committing coercion as defined by section 15, even though you can see the word all three times. But then when we make it into limbs or ways of committing coercion, there are only two ways. Okay, and then despite the two ways here, but the important, okay, the sole consideration is, okay, whether there has been free consent. So it revolves around the elements requirement of free consent when the party entered into the agreement. Okay, if you read it with your contract one last time, you discuss about acceptance, intention, consideration. So everything here are there. I mean, all the ingredients, all the elements are there. But now the next question is whether the parties entered into the agreement with free consent or not. Okay, despite that they have given, I mean, there was of acceptance, intention, and consideration. Okay, we go to the facts. Okay, just now this is the ratio of principle, and this is the facts. In order to make a smoother explanation, okay, discussion, okay, I mean the easy way of discussing the case is to identify the parties first, okay, and then we know what happened between them. What's the dispute between them? So the plaintiff in this case, he was the vendor, okay, the seller of round bars. So that's the picture of round bars. Okay, any bar is a round bars, the bars in round shape. And who are the defendants? Okay, defendants were the purchasers, the one who bought the round bars. So we have to know, okay, what's the price here? So it involves agreement for the sale of round bars, okay, and this is the purchase price, okay, the initial one, 1,180. But later they have dispute about the price here. And before they actually make the agreement into writing, okay, before that they have discussion and negotiation. Okay, so the first defendant, the purchaser, he had confirmed order for the goods by letter, okay, in writing, and the price stated as 1,244. Okay, whereas during the discussion it was lower, okay, had 1,180. Okay, so there was discrepancy here. And then they have exchanges of letter, okay, several exchanges of letter, and the vendor, the one who is selling, he maintained that there was an error in the price because the seller wanted to sell at higher price, whereas the buyer wanted to buy at lower price. Okay, so the purchaser insists that the plaintiff were bound by the price, meaning that, oh, you promised to sell to me at this price. Whereas the vendor said, no, actually the price is 1,244. So that's dispute regards to the price here. But the seller, the purchaser was really, was really in need, okay, of the item, subject matter here. Okay, and then the purchaser paid a deposit, okay, paid a 15% deposit to the agreement. But the vendor, okay, the seller said, no, I'm not going to supply unless you agree to my price, okay, which is higher, 1,244. So the purchaser doesn't have much choices here. Okay, so the price was resolved amicably when the first defendant, the purchaser, by their letter, they agreed. Okay, we agreed to your price, but later they, okay, here later they agreed first, and later they don't want to pay. They disputed and then they brought the case to the court, and this is their arguments. Okay, they said, well, we agreed because the plaintiff, okay, persistently refused to supply, so we don't have choice. We have to agree to the higher price. And then another argument here. First defendant, the purchaser, had committed themselves to producing and supplying concrete. They have some commitment here. They say they need the bars, okay, because they need to produce and supply concrete. And then another argument, well, we don't have time to look for other supplier, okay, to supply to us the round bars. Okay, and then the case actually was brought both under 15 and 16. Okay, in civil cases, it's possible for you to bring a case with many grounds. Okay, you have section 15, section 16 as the ground in your statement of claim. So in this case, there was an inference of undue influence and or caution within the meaning of section 14. And if these elements, if these factors, vitiating factors are proved, it will nullify, okay, and invalidate the agreement. Right? This is the effect lah. But the party need to prove whether the elements was fulfilled or not, okay, whether the factors was there or not. So in giving the decision, okay, the court examined whatever things happened between them, okay, and the court came, this is the judgment, okay, this is the court said clearly, expressly, by way of interpretation of section 15 here. The court said there are two ways of committing coercion, okay, if you look closer. Okay, the first one, I put in different color font here, okay. one. One of which is the threatening of the act forbidden by the penal code. Okay, that's the first one. And another one, while the other is unlawful detention or the threatening of such to the prejudice of any person, okay, with the intention of causing any person to enter into agreement. And then as far as the first defendant case was concerned, okay, despite all the argument, okay, the court said, yes, we agreed, okay, we accepted the argument that yes, you were subjected to commercial pressure. So they were under pressure, okay, because they were in business, in commercial transaction here, commercial world. Okay, when the first defendant, okay, now they are faced with prospect of not getting supply of the bar. That's why they agreed to the new price. But is commercial pressure something which falls under section 15? Is it caught by penal code here? The court said no. Okay, it does not amount to coercion because the agreement to the price was an exercise of free will. Nobody forced you to really buy it. Okay, nobody point for example, extreme example. Nobody say, oh, I will hit you if you don't sign the agreement, for example. Okay, I mean, you have the right. You can back off from the transaction, but you choose to accept. Okay, because you were under commercial pressure, not the not really the something which has the criminal elements in it lah. Yeah, all right. And okay, so meaning they had the first argument was rejected by the court. There's nothing about there's nothing that we can relate to penal code. Okay, and another argument by defendant, defendant said, well, plaintiff refusal, okay, vendor's refusal to supply the bars at a lower price. This is actually unlawful detention of property. Okay, you detain the property unlawfully so that you will get me to sign the agreement. All right. So basically, this is an attempt to prove the case under second limb. Okay, second limb is about unlawful detention. But again, the court rejected the argument here. There was detention of property here. All right. But was it unlawful or not? Who actually owned the round bars at that moment of time? Okay. The court said, well, this is something which is lawful. It's not really unlawful. This is lawful because plaintiff, the owner of the round bars, okay, has yet to sell it. Okay, so has yet to sell it. So because plaintiff was exercising his legal right of his own property, it will be different if the property, the round bars, belong to the defendant already. Then it will be unlawful. Here, okay, you haven't paid yet. All right. So and we haven't come to the agreement. They haven't come to the agreement of the price here. Okay. So there was detention of property, but it was lawful. So again, second limb was not fulfilled. Okay. So as far as the case was concerned, the party, okay, failed to prove the case under either of the limbs, both limbs. They tried both, but then the court rejected both arguments. So that's basically the case of Taekwon trading. That's the first case. All right, the first case law. Now we are moving to the second case for today. Reported in year 2006, Nuri Asia, Senayan Berhad, and Forces Corporation, Senayan Berhad, and another. Also another argument which was made under section 15. And the case is important because why? The parties actually managed to convince the court, managed to prove the case successfully. So they were successful as compared to Taekwon just now. Okay, argument, okay, whatsoever. And then the court rejected both claims, even though they tried to prove it under both limbs. But for Nuri Asia, this is example of successful case under section 15. Okay, let's get to know who were the parties here. Plaintiff here was the claimant. Okay, claimant was the claimant lah, the one who claimed. And he was also the creditor. Creditor is the one who give the money or who give the things or payment on credit. I mean, a payment has to be made to him lah, creditor. Okay, and first we have two defendants. First defendant was the principal, the main debtor, the one who owe money to creditor. Okay, and second defendant here, not the debtor. Okay, they are not the one. I mean, he's not the one who owed the money here, but he's the guarantor. He will guarantee. Okay, if you don't pay, then they will jump into the shoes of the debtor lah, guarantor. Okay, that's why we have first defendant, second defendant. And it's a big amount of money involved here. Okay, 1 million plus, 1,182,970,000. Okay, 20 cents. So here, okay, the purchase was made. Sale and purchase was made on credit. So being the price of goods sold and delivered by the plaintiff to the first defendant. And there was oral guarantee, meaning okay, if you don't pay, then there's a guarantor that will pay. But it was done orally. Right, and the oral guarantee, okay, was allegedly given by the second defendant to the plaintiff, and later actually they make it into writing. First it was in oral, and later they reduced into writing in the form of letter. Okay, and then what happened was that later the debtor didn't pay. Okay, plaintiff cannot get the payment. Then he lodged a police report, okay, and prepared the written guarantee for the second defendant to sign. Again, meaning he wanted to get the money from the guarantor instead of the debtor. Okay. But now the guarantor said, no, I'm not the guarantor. I refuse to be, it wasn't my wish to be the guarantor. Okay. Second defendant denied that he was a guarantor. Okay. Otherwise he has to pay. All right. He will be in the debtor's position. Okay. He pleaded in his defense, okay, when the case was brought to the court, when he was being sued, okay, by the plaintiff here, he pleaded in his defense that he was acting under coercion. He doesn't want to be guarantor, but he was being coerced to be the guarantor. So he was forced by the plaintiff director, okay, because plaintiff is the company, okay, plaintiff director and shareholder to sign the written guarantee. Okay, whenever the important thing is that, okay, in order to prove the claim, okay, of coercion, it has to be proved strongly. You cannot simply say in the court, oh, I was being coerced, I was being forced. Any evidence? No evidence. So here, the second defendant, the guarantor, was so smart. I mean, he has all the strong evidence here. So basically what happened was that when he was forced to sign the written guarantee, he quickly went to the police station. He lodged 2 police reports. Okay. Okay, we have 10 minutes left. He lodged 2 police reports. First on the date of the written guarantee, 4th April, and another one on 13 April. Remember, okay, police report, you cannot really make a false claim in the police report. So meaning that here, there was really coercion, which was being on him. Okay, he was being coerced to sign the agreement. Okay, and when the court, heard all the defenses here, and then all the evidences produced here, and this is the judgment, the finding by the court here. Okay, the court said, well, the written guarantee, okay, was executed, it was signed by the second defendant in a very unorthodox circumstances, not in a common style here. Okay, I mean that, and if you read, it was signed in the restaurant, and then there's bodyguard whatsoever. So I mean that here he was really compelled, he was really being coerced. Okay, and then the second defendant's police report contained all the materials particulars. So meaning that here there's no way that the coercion didn't take place. It took place lah, basically, okay, pertaining to the circumstances surrounding the signing of the written guarantee. Okay, yes, so the court agreed. Okay, now, yes, the written guarantee had been tainted, okay, affected with coercion as defined in section 15. And yes, because of that, no free consent. Meaning here when you signed, it was not your wish to be the guarantor. So the written guarantee was invalidated, was void. Okay, we cannot really enforce it. Okay, that's the thing, that's the effect, okay, of so now the contract that we're talking about here is about written guarantee. First, it is oral, but later it becomes written guarantee. It was reduced into writing. Okay, actually, we are supposed to finish everything about coercion today, okay, but you don't have to worry because there's a video on this. Okay, I have prepared the one that I recorded last semester. Okay, video about relationship here. You can have a look at. I mean, you can watch the video later so that we don't have to. We can have a quick look on this, but you can. The detailed discussion or explanation is in the video. Okay, it's about relationship between section 15 and 73. Meaning that here after 15, the next section we want to discuss is section 73. Why suddenly? Okay, because in section 73, there's a phrase, there's a word under coercion. So now the question is it the same like coercion under section 15? Okay, bearing in mind section 15, very, very limited scope. So 73, is it the limited scope or is it a broad scope or general scope here? So this is the case, all right. It is, you can have a look at the video later. Okay, I discussed about Chinambi. Okay, you have the slides with you as well, so you can have a look. And this is the argument. Okay, so basically, in Chinambi, the court held that coercion in section 73, they are not synonymous with 15. Okay, because 15 limited use, but 73 broader. But the scope, okay, the context that you can use 73 is not applicable in all. Okay, the specific usage of section 73. After this, I'm showing you section 73. Okay, and this is for economic duress. This is another part of the topic. It is actually the law at common law. Okay, common law. So in Malaysia, there's a big question whether we apply or we don't apply. Okay, this is the case from common law, is in the video. All right, the big question. Okay, this is the big question. Okay, after discussing position at common law, but now we want to know what is the position in Malaysia. Okay, on top of section 1573, do we have any provision related to economic duress in Malaysia? The answer is no. So that's why the position is unsettled. We are not sure. Do we allow the application of economic duress in Malaysia? Okay, or we don't? So there are two approaches here. Okay, one the rigid one, another one the flexible one. But which one is the better approach or better application? No answer, because both cases here by High Court. I mean the Court of the Same ranking. If the judgment by Court of Appeal or Federal Court, it will bind all the lower courts lah. But until now, we don't have any latest case on this. But I'll have a look at the textbook that I have just bought. See whether there's any updates on the case. But as far as I know, when I do the manual searching in LexisNexis, I cannot find any latest case on economic duress in Malaysia. In the year, most of the time, the courts are reluctant to allow economic duress in Malaysia because it is something which is based at common law. Okay, here this is the case. It's in the video. You can have a look later. All right, and this is the last part of our discussion. Okay, we want to know what's the effect of the contract being affected by coercion. So another relevant section will be section 19. The contract will become voidable. Okay, not void straight away. Voidable means here the parties have the option to proceed or can stop. I mean, can invalidate the contract. But most of the time you want to invalidate. That's why the party goes to the court. Okay, but the effect is voidable. It's possible to be valid lah here. Okay. And when we talk about void contract, the interpretation is in the section 2J and also section 66. Okay, 66 is about void contract. Okay, it talk about obligation of person who has received advantage must restore. I mean, you have to return now because the contract is now void contract. Okay, and this is the remedies lah, rescission. Okay, to rescind, to set aside, and restitution. We restore the parties back to the parties' earlier position. And this is just additional reading. Okay, I stop share. I want to show section 73 just now. Where's the contract slide? Okay, 73. Let's go to 73. 75. Just a simple section, but it's very specific application here. Okay, it talk about liability of person to whom money is paid. There must be money payment, then only you can apply 73. Or thing delivered by mistake or under coercion. So it says here clearly, a person to whom money has been paid or anything delivered by mistake or under coercion. Okay, what's the liability? What's the responsibility here? Must repay or must return it. So it doesn't concern with the way coercion was being committed here. It's about liability. It's about remedy here. I mean, if you receive the money paid under coercion, then the party need to repay, basically. All right. So this is the illustration. A and B jointly owed 100 ringgit to C. So A alone pays the amount to C, and B, not knowing this fact, pays 100 ringgit over again to C. So C is bound to repay the amount to B, but this one for mistake. Okay, by mistake or under coercion. All right, the second one. A railway company refuses to deliver up certain goods to the consignee except upon the payment of an illegal charge, okay, for carriage. So the consignee pays the sum charged in order to obtain the goods. Okay, meaning this is under coercion. So he is entitled to recover so much of the charge as was illegally excessive. So impliedly, there's elements of coercion here. Okay, it's not under mistake here. Is it under coercion? Coercion as general meaning, not really coercion. If we relate with penal code, so we don't bother. We don't care about penal code. Okay, that's at 73. You can have a look at section 6 and also section 2J on your own. Okay. I stop share and I stop. Do I stop button stop record?